So I wanted to, talk about the Digital Services Act and put that a little bit in perspective, and put it also in particular in perspective of, like a computer science and law research agenda. So, I'm very happy to be able to make this contribution. I think there's quite a lot of interest, of course, in what is happening in Europe. And I will speak a little bit to that. And I'm very happy also to see that in a workshop like this, hosted in the US, there is that, attention and interest in taking a more international perspective also, which I think is extremely relevant for, computer science and law research agendas. So you probably have, come across a few of these types of instances where European kind of like high-level officials are engaging, in discussions with big tech. This in particular, Thierry Breton, warning Elon Musk that there will be rules for content moderation. So you shouldn't think that he can take a free speech absolutist approach with Twitter if he manages to actually acquire it. And there's a lot of news like this over the last time. Like this is actually just earlier this week. This is actually a little movie that you can find. It was shared by Thierry Breton on his Twitter feed just 2 days ago. It's pretty cringeworthy, and Elon Musk doesn't really know how to deal with the situation. But like a lot of these types of interaction showing the appetite of European regulators to engage in this space, and this, of course, of content moderation specifically. But I think maybe if we look at it a little bit transatlantically, and like we can see also these types of analysis where on the European side of things, if you look at content moderation, we see more and more law. And in the US, we see a lot of discussion and also some quite high level and high quality discussion on these types of issues. But of course, less progress on new regulatory frameworks. Like leaving aside the question, of course, on the topic of content moderation specifically, you would like to see more regulation. But that's quite a relevant divide. And really, I would say, if you look a little bit more broadly than content moderation, messaging services, you could maybe still include as a content moderation type of issue. You see that Europe is moving ahead at speed with introducing like a vast number of new regulations in the technology regulation space. And it's doing that at a quite remarkable speed in ways that I think are super relevant for the community that is coming together for this workshop. So this in particular is an element from the new Digital Markets Act that is being adopted also this year. The text is finalized, still needs to be kind of officially voted, and it has messaging interoperability included into that. So just an avalanche of new EU regulations in the digital space. I've made a little bit of an overview just to give you a sense of basically how overwhelmed we are also as information law experts in Europe trying to keep up. So I've highlighted the content moderation relevant elements, in particular here in yellow, the Digital Services Act, which I will talk about. But there's a bunch of more specific regulations in this area too, on copyright, on terrorism content. Just today, a proposal on child sexual abuse material, and a whole bunch of stuff on disinformation as well. But apart from that, a whole bunch of instruments in the area of data governance with new Data Governance Act and so-called data spaces, a new Data Act that is under discussion, a new AI Act that is going through the legislative process, a whole bunch of proposals in the law enforcement, the cybersecurity area, and a whole host of updates of more general law. So Europe is extremely active in the digital regulation space in the last years. They had already an appetite for regulation, but it's kind of escalated in the last years. So I wanted to, it could be interesting to say, why is Europe really doing this? And what is really motivating Europe to pass all these regulations in the first place? I'm not going to go into that in this talk, but I would say, generally speaking, that the digital transformation, is kind of taken as a constitutional opportunity for Europe to to define itself and to redefine itself, to assert itself in relation to other parts of the world, other regions, in relation to the US, in relation to China, but also in relation to big tech and in relation to, of course, its own citizens and industries. What I wanted to do in this talk, I want to talk about the Digital Services Act in particular, but just to kind of put that a little bit in perspective, I want to talk about the two kind of main kind of instruments of platform regulation that Europe has been working on in the last years. And the first one is the European Union Digital Markets Act, and the second one is the Digital Services Act. So the Digital Markets Act, it complements European Union competition law. It regulates so-called gatekeepers in digital markets through a specific set of structural and mostly behavioral prohibitions and obligations. So, and gatekeepers are, they're automatically kind of considered gatekeepers under certain conditions, or they can be designated as such. They're market players with significant market power. But substantively, they have to be some type of core platform service, and which is a broad definition of different types of platforms. And they include more interactive platforms, for which the DSA also has regulations, like market platforms and social media, but also more technical platforms like developer ecosystems. This is asymmetric ex ante market regulation. So where competition law is ex post, it's reactive. This is like setting certain rules of the game beforehand. It's asymmetric in the sense that these gatekeeper rules, they only apply to the gatekeepers that have to be assigned like such. And so, like I mentioned, it includes interoperability requirements for messaging services, one of the rules, but there's a whole bunch of other rules with respect to data and the treatment of users of platforms. So the Digital Services Act. So the Digital Services Act is a proposal that basically entails a very broad platform regulation package at the EU level. It really grows out of the rules that we have on intermediary liability, like you have in the US, CDA 230 or the DMCA, but it's really extend those rules, and it broadens the scope of it. It's really not just with legal liability questions, but it constructs a certain platform responsibility. This imposes a new framework of so-called due diligence obligations with respect to, content moderation and the responsibility of platforms and the procedures that platforms are using with respect to illegal content. And what it does, it is then putting all of that and all those services that comply with it under regulatory oversight. The primary focus is really, and you can see that also from the discussion and also from some of the provisions, it's really on social media platforms and online marketplaces kind of platforms, trading platforms. But ultimately, all online services that are dealing with third-party content, they are in scope of this new regulatory framework. There's a special regime for so-called very large online platforms, FLOPs, and that special regime is especially interesting because it imposes a new innovation of risk management obligations on content moderation practices, and I'll speak about that more. So, generally speaking, what has happened in Europe with the DSA is that we're moving from a space where there's some baseline rules and a lot of self-regulation and a lot of regulatory guidance, including from the European Commission and a bunch of code of conduct. We're moving to a much more heavy public regulation framework for online platforms. We have had a political agreement on the DSA just a few weeks ago, but the adoption is expected together with the Digital Markets Act in July 2022. So I want to speak to a number of the specific innovations in the DSA that I think are particularly interesting from a computer science and law perspective. So first of all, and that's of course interesting for a workshop, I thought, that is on content moderation. The DSA has an actual legal definition of content moderation. So you find that in the definitions. I've taken the version of the council. The final version, the final text is not yet available, but this will be pretty close to the final text. And it's pretty broadly defined. Content moderation, it is the activities, automated or not, undertaken by providers of intermediary services, aimed in particular at detecting, identifying, and addressing illegal content or information incompatible with their terms and conditions. So both the illegal, kind of legal-illegal boundary, but also the terms of service boundary, provided by recipients of the service, including measures taken that affect the availability, visibility, and accessibility of that illegal content or that information, such as demotion, demonetization, disabling of access to, or removal thereof, or the recipient's ability to provide that information, such as termination or suspension of the recipient's account. So quite an extensive, actually, definition, which is relevant because of, it feeds into the scope of some of the other obligations in the regulation. So I've just flagged a few items of relevance of this legal definition. First of all, it plays into the scoping of the regulation of terms of service for content moderation in Article 12. I'll talk about that next. It also helps to determine the scope of transparency and transparency reporting obligations, which you find many of in the DSA. And it also helps to determine the scope of risk management framework, for these dominant platforms. So the DSA, quite interestingly, in this very specific article, Article 12, puts forward a new provision on the regulation of terms of service. And so this Article 12, and it has a few different elements. So the first element is the requirement to be transparent about the terms of service, and also, let's say, a certain kind of completeness. So when there are restrictions on the use of a service, they should be included in the services terms of service. And furthermore, the policies and procedures, measures, and tools used for the purpose of content moderation, including the algorithmic decision-making and human review, so really policies, procedures, and measures, and tools, they have to also be described some manner or form in the terms of service. So that's really, by and large, it's like a transparency kind of thing, transparency requirement. The second part of the provision, it gets more interesting. This is about enforcement requirements. So, of course, it's like a lot of potential discussions about how terms of service get enforced, and considering the stakes, in the online environment. Also, in particular, I think from a public, debate perspective, there's been a lot of discussion in Europe, about, big tech, doing this privatized enforcement, there not being enough accountability. This provision puts restrictions. It determines that the restrictions, which amount to content moderation, they should be applied in a diligent, objective, and proportionate manner. So I've taken this from the European Commission text. What is quite likely is some additional words may be added to the final text. European Parliament had proposed to include the following qualifiers: fair, transparent, coherent, diligent, timely, non-arbitrary, non-discriminatory, and proportionate. So really quite a lot, and quite a lot to digest, and also quite a lot to kind of, wrap our heads around what it means exactly. And some of those words actually could be interpreted in very constructive ways, but I think also some of those qualifiers could be interpreted in less constructive ways. And then finally, there's an additional, more general requirement that the terms of service enforcement should happen with due regard to the rights and legitimate interests of all parties involved, including the applicable fundamental rights of the recipients of the service. And that gets very interesting because we have in Europe, we have a bunch of case law that the right to freedom of expression as relevant in these horizontal relations between the platforms and the users thereof. But also you can imagine rights to non-discrimination, data protection, those types of rights also playing into this kind of terms of service requirement. So I think this is a very, very interesting, from a legal perspective, from a regulatory perspective, it's a very important new provision. And it will be very interesting to see how exactly, courts will start to interpret that, but also how the regulators will start interpreting this new requirement. So the DSA is really, like I mentioned, we're going from self-regulation to regulation, and the DSA is ultimately really an enforcement law. The idea is we have all these laws with respect to legal content, illegal content. We have intermediary liability framework with certain safe harbors. We have a mostly like reactive, obligation on hosting platforms, through notice and takedown procedures to deal with illegal content issues, but it's all about enforcing ultimately these underlying substantive like laws, like defamation or terrorism content or all these other types of underlying legal norms. What we see in the DSA, we see basically a whole codification of soft law instruments that have emerged in Europe in the last decades, including like guidance on notice and takedown systems. Like I mentioned, also we see new creation of new regulatory oversight, and it's a combination of, on the one hand, the national level will have digital service coordinators, but also the European Commission will have an important role. In particular, there will be centralized enforcement for the obligations on dominant platforms by the European Commission. And that it's a bit of a compromise. It happened actually because some of the larger member states, they were uncomfortable with being dependent on enforcement of the DSA with respect to some of the larger platforms. Let's say the Irish regulator. There's been some bad experiences also with that, like the way that was functioning in the data protection space, with the GDPR. And so ultimately they ended up with a compromise that, there's a little bit more centralized power for the European Commission to take that role with respect to the dominant platforms, including like services like YouTube and Facebook. There are also individual complaint procedures at the platform level. So for instance, the possibility to complain about removals, and also the possibility to complain to the digital service coordinators of your country as a citizen about non-compliance with the rules. So that adds to the kind of enforcement landscape. And finally, there are new mechanisms also to enhance the role of research and civil society. And in particular, there will be data access for research. There's a data access for research provision in Article 31. And really, transparency and accountability is what is driving a lot of what is happening in the DSA. So the DSA has a whole host of new data and reporting requirements on content moderation. And so, like I said earlier, with Article 12, transparency about certain things that should be in the terms of service, but also transparency about what is really happening with respect to takedowns and getting more numbers out of that. And for the very large online platforms, for the dominant service providers, we have a whole bunch of additional transparency requirements, including this requirement to have specific research data access for the dominant platforms in Article 31. For vetted researchers, that much is clear. And as far as I have understood, they have opened now also the door for the use of that provision to get access for researchers like in civil society. The DSA is taking this tiered approach to the responsibility of intermediary services, like any kind of internet service, internet-based service that is dealing with user-generated content, third-party content. The most basic obligations, they apply to all intermediary services, including Article 12. Then there are additional due diligence requirements for what are called the hosting services. And the hosting services are basically, it's a similar kind of category that you find in the DMCA. It's like, you could say, if you talk in like old-fashioned kind of legal doctrines, these are the distributors. These are the sources of online material, the hosts. There are then additional due diligence requirements for hosting services that are making things public. This is my very basic summary. This is the online platform definition that you find in the DSA. So online platforms are hosting services, but that facilitate actually making things public. And then finally, there are these additional due diligence requirements, asymmetric requirements on dominant online platforms and search engines. So, and in that package of additional, requirements for the dominant platforms, what stands out in particular, I think, is the introduction of the risk-based approach for dominant platforms. So there are these additional due diligence requirements, and their risk is explicitly introduced then in two ways in the DSA. So first of all, it is used as the argument to introduce asymmetric obligations for dominant online platforms. So why do we have these kind of additional obligations on these dominant platforms? Because they are more risky from a societal perspective and from a user perspective. And then secondly, risk is operationalized in the requirements to manage systemic risks related to content moderation in Article 26 and Article 27. Article 26 about the identification of the risks, and Article 27 the requirement to effectively mitigate those risks. And then there's a provision on the auditing of those risk management practices in Article 28. I've just copied a few of the elements from from those provisions. I've taken like the proposal text, but systematically it's mostly going to be looking like that. So in Article 26, the requirement to conduct this risk assessment, and that has basically, like the dominant platforms have to do that in three kind of main buckets of systemic risks. The first one being the dissemination of illegal content through the service. The second one dealing with the negative effects for the exercise of fundamental rights. And then there are a few fundamental rights mentioned in particular: private and family life, freedom of expression and information, non-discrimination, and the right of a child. But there's actually, the question is that could be broadened still a little bit. And then the third bucket is manipulation of the service, and that really connects to the concerns there are about certain types of disinformation campaigns. And then Article 27 is the requirement to mitigate those risks, and there you can see that the qualifiers there, that the risk mitigation measures have to be reasonable, proportionate, and effective. And so this is then also made subject to regulatory oversight by the European Commission. So I want to just conclude by saying a few things about what to expect of the introduction of the risk-based approach for dominant platforms. So what to expect? Is this a regulatory experiment? We've seen the introduction of risk in quite a number of new European regulation. The risk-based approach was also introduced in the GDPR. That was an innovation in comparison to the data protection framework that we had. We see it in the AI regulation. We see it now popping up more and more. But really, if we look at the DSA, the question is, at what level, I think, can we expect the risk assessment and the mitigation of Article 26 and 27 to operate in practice? It's quite clear that you can get quite granular, and maybe that's also necessary to do meaningful work on risks, on the illegal content types, on the specific fundamental rights issues that you can identify, and also on the very particular service manipulation possibilities that exist on dominant platforms. And so, but how granular exactly we can expect those risk assessment and mitigation procedures to be, it is not entirely clear. I think it's clear to me that it's very important that the more technical communities help to inform that discussion. It's not exactly clear also how the European Commission oversight will function, and which risks the European Commission will pay particular attention to that they're addressed effectively. A question considering the fundamental rights systemic risk bucket is also, how can human rights impact assessments that are already happening, of course, effectively inform the DSA framework in practice? And this is where a bunch of civil society actors have, plead to, made the plea to make sure that those types of practices can help inform what is happening under the DSA. How can risks, including related to illegal content, be effectively operationalized? And finally, what I would say is that I think what we can expect is that specific regulations, vertical regulations on more specific issues, they may build on this DSA framework. For instance, the child sexual abuse material regulation, the proposal that was issued today, but also perhaps things like the implementation of the copyright upload filtering obligations. In Article 17 of copyright in the digital single market. And so that is where things will get, I think, very interesting, like to see that this is actually, it's somewhat of an umbrella framework, but over time, maybe already in the next 5 years, we see the inclusion of all sorts of more specific kind of content moderation risk management obligations in more specific regulations in the EU. And so, just an example of that in the new European Union child sexual abuse material proposal that was issued today by the European Commission. And I've just copied just a part of Article 3 on the risk assessment. There's also an Article 4 on the mitigation measure. And this is just a part of the article, and it gets extremely detailed. And there you see that maybe also then in these particular areas, we can expect very, very specific risk management practices to be required, and the need, of course, for them to be developed. I wanted to also just flag this other part of this new proposal, because there's been a lot of discussion about the technologies that Apple was proposing to introduce on the scanning, the device level scanning of images. And this is from this new regulation, and it's quite clear that it's referring to potentially similar technologies being, required by European regulations.
So, Joris, I just wanted to say in a few minutes we should start Q&A.
Yeah. Thank you so much. Yeah, I'm almost done. So the final thing I will say about the risk management framework is I feel like there's two kind of not conflicting but interacting perspectives on risk and content moderation. So on the one hand, we have the perspective on all algorithmic content moderations as systems that can produce systemic issues that need to be monitored effectively and addressed. For instance, you can imagine issues with respect to discrimination of algorithmic content systems, certain forms of bias that you would want to see monitored and addressed. On the other hand, of course, we see that the mitigation requirements, the mitigation of risk stemming from content moderation will likely lead to the development and the requirement or the implicit requirement of more algorithmic systems in content moderation. And I think it's between these two kind of interacting perspectives that this risk management framework can produce a lot of work and a lot of interesting questions at the interface of computer science and law. So just to conclude, the DSA will regulate content moderation on online platforms. There are several provisions that create new research opportunities and challenges for CS and law collaborations. Research access and the risk-based approach, I think, stand out as a particularly relevant innovations. And then as a final remark, there's really this dimension, of course, in all of this of like cross-disciplinary collaboration on content moderation. But I think what this is also showing, like in this context, there's also, of course, the need to look at this cross-jurisdictional exchange and collaboration, in particular because with content moderation, we are talking about transnational governance mechanisms. Thank you very much, and I look forward to answering any questions. It was a bit of an explainer, perhaps, but I'm totally happy to explain more. I hope it was not too half-baked, although I did, put the presentation together just for the workshop.
Okay, thank you. So I am going to exercise my prerogative as the session chair and ask the first question. So it's actually a good, your last point, Joris, about the cross-jurisdictional nature of this Digital Services Act is a good segue into what I wanted to ask. So as an American, I guess I'd like to say that it strikes me that Europeans seem to be a lot more serious about strict regulation of internet activity and a lot more generally optimistic about, or at least I'm inferring you must be very optimistic about how much good these strict regulations can do. So I was wondering, GDPR was a great example of something that I think was a very ambitious exercise in regulation. And we've been living with it for a long time now. We're all aware of it. It imposes itself on our screens and in our browsers. And I'm just wondering, from a European regulatory point of view, is GDPR viewed as a success? I mean, I think that it has definitely been a success in that it has been a presence. People are coping with it. People are complying with it. We're all doing a lot of box checking and, agreeing and this and that. Is there a general sense that it has really fundamentally improved privacy of internet users? Or is there no conclusion at all yet? Or what is the feeling now that we've actually had some very omnipresent European-style regulation for a few years now?
It's a big question, and I maybe want to also flag in particular the way in which the GDPR debate has informed, the discussion on the DSA, because that has really happened. And I think you rightfully point out that the question of whether it's been a success, it depends on the perspective you take. And maybe a very good example that goes a bit to the content moderation topic too is the right to be forgotten. The right to be forgotten actually being imposed on the basis of the kind of predecessor of the GDPR, the Data Protection Directive, interpreting the rules and applying them to search engines and their operation of an index and a search engine, and then saying people have this right on the basis of their general rights, data subject rights, to request delisting of particular search results for a search on their name. There was a lot of discussion. I was part of that discussion too, and I've always been really critical of that ruling. I think it's a total shortcut. I think there are situations where maybe delisting is legitimate, but I think by and large you should try to deal with the issues at the source. But at the other hand, I do have to acknowledge that it's been a success. It has had a real impact, and it has also helped people to protect their reputation in the online space. So it has this kind of very clear effect, but maybe I disagree with it. So, but on the GDPR generally, I think the one thing that kind of is quite generally accepted is that the enforcement is not functioning optimally yet. And that is really one of the really big issues, is that there's quite complex framework for enforcement with the one-stop shop and an important regulator of important role of these national regulators, and sometimes they're just not really managing to do a good job for good or maybe also for bad reasons at times. And that is really, you see that really informing that it really informed the discussions of the DSA. Where a country like France or maybe other big member states, they just wouldn't accept that the regulatory authority on the DSA with respect to the big platforms would reside in a particular kind of member state that maybe has too much political interest by a relatively lax enforcement. So that's why we see this more centralized role for the European Commission. And the fact that member states actually pushed for a stronger role of the European Commission is a very interesting dynamic from a European perspective. So then the question that I have is how is the European Commission going to really get to be accepted as a legitimate entity in this content moderation space? And there I think, and I've told people also in the Commission, that I think they're too optimistic about, I think they have a relatively kind of technocratic vision of what this kind of oversight, monitoring oversight, is going to entail. But I think they underestimate how, politically complicated and complex the regulation of content moderation really is. And I think there we will probably, I don't think we're there yet. I think it would be much better, in my personal opinion, if we have this regulatory oversight at the EU level, to develop an independent agency, that is very kind of, appropriately staffed with all the right types of expertise, including on, freedom of expression and media freedom issues.
Okay, good. So, Tarleton, why don't you ask your question with the microphone?
Thank you. Appreciate it. Hey, Joris, thank you so much. It's always good to have you as an explainer. What a great way to start. I wanted to ask you, you got to this in the last slide, but I wanted to ask you about this idea of systemic risk. So I'm really curious what's sort of animating that question, because if we get to this like imagination of very large platforms having this additional obligation, and we set aside the sort of illegal content for a while, this other part that they've kind of framed as like manipulating the system, which I find a very strange way to put it, because it's like, well, that only depends on what you think the right use of the system is. So it's but I get why that's a safer argument than we worry that you're amplifying something that is legal in the strictest sense, but is having this consequence, right? So not just like what topics are animating it, clearly it's disinformation and terrorism and conspiracy, but like what's going into the thinking of what are these systemic risks? Is it strictly the kind of like you're cheating the system according to the terms? Is it touching on these arguments that like amplification might be its own problem, bigger than sort of takedown of bad content? And like what do you think is in there? How much room does that idea have for arguments that are about sophisticated systems that have sophisticated consequences, not just big systems that have bad content on them?
Yeah. Great to see you too, and so sorry not to be able to see you in person, Talton, and also others that are there. So it's a really good question. I think the point you make about the regulation kind of connecting itself to what is the norm of the system, like it flags I think something very important, which is that in the whole risk regulation approach, you see that the regulation, the DSA, makes itself really quite dependent on a whole bunch of choices that are going to be made by the company themselves. They, in the first instance, they have to do this risk regulation work. And actually, until I saw this child sexual abuse material proposal today, I was quite convinced that it would be a really open space. Now I feel that maybe on these particular issues, we see just other regulations stepping right into the framework and specifying much more granularly what needs to happen. And I can imagine that happening also in the disinformation space under that kind of bucket. But it's really true that, this question, what is the right use, what is the manipulation of a service, is like, what is the appropriate way to use an account, are you allowed to do anything automated ways, or you see that also of course in the discussions around bots, and by and large I think law has made itself dependent on the definitions of the platforms themselves of what is the appropriate use of the service. And as we know that there's problems with that, objectively speaking, there are types of manipulation of service that are socially productive ways of using the service. I totally, I really follow your point, and I think it's something to look at quite carefully, and I would hope that people that are in the disinformation research space will be following this quite carefully, and I imagine we'll also be able to have a role, in operationalizing, this framework. I think there's quite a lot of thinking probably within the big companies of how to do risk management, and content moderation. But I would hope that there would be a more open conversation, and hopefully, like the reporting and the oversight will also help to construct that conversation.
Yes. Could you introduce yourself, please?
Sure. Thanks, Joan. Thanks, Joris. I'm Gavin Sullivan from Edinburgh Law School. Thanks. It's a great explainer to the DSA. It's always welcome to hear. It's such an ambitious piece of legislation. Just a couple of kind of specific points I wanted to go back to in your presentation. The point about Article 12 and the obligation to apply terms of service in an objective and proportionate manner, is the aim here to push the application of terms of service by platforms in a way that's going to be compliant with the European Charter of Rights? And is the expectation there that all of the European case law on proportionality will be brought to bear in that process? Because if so, I think that's a very interesting move, and I'm wondering if you could say a little bit more about that and how that's going to work in practice. And the second point, which I think is really groundbreaking, which you touched on, is the question of third-party researcher access in Article 31. I'm not aware of any other piece of major legislation that makes that opens up the hood like that and gets that kind of access. What kind of access is going to happen in practice? I mean, what are people going to get access to? Who's going to be vetted? How's that going to be controlled? How's that going to look like in practice? If you can say a little bit more and elaborate on that, and whether you think it's feasible and it's going to live up to its expectations, I think that'd be fantastic. Thanks.
Yeah, great questions. Yeah, I do think, like, for the reason that you mentioned, I'm so interested in this terms of service regulation, and there's this very kind of clear reference to the fundamental rights, and we have a whole bunch of, case law on, the horizontal effect of fundamental rights, and we've like constitutional case law from Germany that, derives certain due process requirements from the right to information, in these types of relations, and we see it in a whole bunch of other countries. You see it too, and now we have like a regulatory kind of mechanism there with oversight, and so there can be very complex but interesting and hopefully productive interactions between those particular things. The one thing I will say is, if you look at the provision, it says like with due regard to the fundamental rights, but it can be an empty reference. Like it can be, but the fundamental rights only apply in this very, very limited way, or like freedom of expression hardly applies in these horizontal relations. It's like it's more, and of course also the right to conduct a business, like a property, they can feed into these types of reasoning. So it's quite an open question. I have a few colleagues that are working on this quite intensively, and we're planning to do more discussion on this, because we think it's really relevant and it's a really important discussion. Also because exactly we have like that kind of development at the national level in the courts already about these types of questions. On the research access, I'm going to play it a little easy, and I'm going to say there's the super expert on that in the virtual room, Paddy Leersen, my colleague in Amsterdam. He has also written about that already, also on our DSA Observatory website. And I would maybe flag that I do agree it's quite innovative. I do think it is actually somewhat disappointing, maybe, if you start looking at it, what can we really expect out of this? I think people that are in this space would have liked to see more. There are people that are really developing at the moment standards and, kind of what is the way in which we can get the research access to get off the ground further. We've seen a bunch of programs, more like mostly, I think, in a disinformation type of area, but now it's going to be broadened, and it's quite interesting. I think it's very interesting, like to see who will have the capacity to do that kind of work. Where is funding also going to come from to do this kind of work? I think it's very important that there will be sufficient funding to do this kind of research, because like there's so much data is like potentially becoming available, but you need, of course, the capacity to really deal with that. And then I will flag that there is this other regulatory proposal in Europe. It's a broader data governance framework. It's called the Data Act, that has these types of obligations, which you could call, like, I've seen them terms like reverse public sector information, like, where like companies can get access to publicly held data. This is kind of the other way around. There's so much data of public interest held in private hands. Some of that data needs to become available to society, or like minimally to researchers to understand what is going on.
Okay, so I think unfortunately we have only time for one more question. David, is there a particularly interesting question in the chat box? You can say no. If
There's a comment from Patty.
maybe you should get the microphone.
There's a comment from Patty Leersen that that it's also worth pointing out that the risk assessment and mitigation provisions also repeatedly mention recommendation systems, and quotes part of the part of the legislation that calls out recommendation systems as well. And Ellen has a question in person, but she wrote it in the chat. So maybe Joris can answer that.
Okay, go
in
ahead.
the chat if we're out of time.
Yeah, I think we really do need to move on to the next question. Is that the next talk, which is yours, Ellen? Do you want to give up a minute or two to get an answer to this question?
Joris,
Well,
do you want to?
I can.
Yeah, go ahead. Why don't you have Ellen's question, and then she can start a minute late or so.
Well, Ellen, maybe you can ask it.
He's got it. I'm not just asking about audits.
Audits. The question is about audits.
Yeah, so the question is really what these audits really, I think the first question is really what these audits amount to, you know? So I think my understanding, these audits are mostly going to function at the level that what is put forward by the companies as like what they have done in terms of their risk assessment and what they're putting in place in terms of systems of, you know, risk mitigation is actually true, you know, and that's a really good thing. I think that is a really kind of baseline thing that we would want to see. But I don't think the audits are really kind of really going more deeply at the more substantive level, you know, of like what the companies could have been doing and whether they've really appropriately interpreted these kind of provisions. That is at least my understanding. But I do need to also see the final text on this. I think there are big questions of who are going to ultimately do this type of work. Obviously, you know, there's opportunity for kind of a new industry to emerge, and it will be quite interesting to see like who will be leading in that space.
Okay, thank you very much. That was really interesting.